Start when you want.
Just your reaction to the latest settlement, $6 million.
Well, yeah, it's in line with some of the others that we've seen, and I need to, make clear at the outset that I am not familiar with a lot of matters involved in the civil litigation. We're only involved in the criminal arena, and we did not participate, nor did we see the trial that occurred. So I really don't know much about the civil situation.
Well, based on the civil situation's decision, from what I have read of this, the judge found any number of crimes committed by these officers, any number of laws broken, not the least of which is potential murder of this person and lying in their official capacity to cover it up. And you guys have found no crime.
Well, look, have you read our report?
Yeah.
I think it's really important that you read our report because it really outlines all of the evidence that we looked at. And I go through the major witnesses, what they say, and I use a lot of quotes because I didn't want to paraphrase or give the wrong impression. We go through the physical evidence, and that's what we relied on in making our decision. Now, criminal law is very different from civil, and we indicate that in our report, and we talk about it. We talk about the case law, and we talk about the Supreme Court case and the New Mexico court case. I agree, there are differences. I don't know what evidence was taken during the civil case. All I know is the information that we had, the meetings that we conducted with a number of individuals, and all of that is contained in our report. Everything that we had, everything that we reviewed, our meetings, going to the scene, meeting with OMI, and things of that nature. So I can speak to what we did and why we did it.
But are you concerned at all based on the evidence that was generated in this civil trial, which shows no evidence of a gun being wrestled from the police officer?
She said it wasn't credible evidence. She found that it wasn't credible. There was evidence, but she didn't find it to be credible. And once again, I can't second guess. I don't know what she heard. I believe that they had a 4 to 5 day trial. I don't know what she heard, what she didn't hear. I don't know if she heard testimony from OMI. I just don't know. I know that she obviously heard from the detectives that were involved, Hilger and Brown. I assume that she heard from Christine Apodaca, but I don't know if she did that via deposition or if she was actually there in person. I can talk about what we did and why we did what we did. I can't talk about what the judge did. If you want to ask me questions about what we did.
I guess I'm here to ask you about your reaction to the fact that there seems to be much more of this case than your review found. And if you are concerned that these two officers who remain on the street to this day potentially lied about this whole case.
We're looking, first of all, a civil case is a preponderance of the evidence is the legal standard, which is 51%. If they can prove 51% is the standard, then they prevail. In criminal law, you could argue that our standard is twice that. That's a huge difference.
You can bring a single charge in this case,
beyond a reasonable doubt. If you read our report, we found that we did not have probable cause to go forward. We did not find the police officer's testimony not credible. We didn't have their testimony to rely on. We had their statements given. I believe Hilger gave his statement the day of the incident, and Brown gave his statement the day after. And we relied on their statements, the physical evidence, the statements of people that canvassed in the neighborhood, and we looked at all of Ms. Apodaca's statements, and we reviewed them pretty specifically as to all of the inconsistencies and some of the consistencies with the officer's testimony. And we concluded that we could not prove this case beyond a reasonable doubt. And I further state that because of her contradictions, and if you want me to go through them, I'd be happy to, that it would be fatal to any kind of criminal case. Please understand, our standard is probably twice what it is in a civil case. We can't just prove probably or beyond, preponderance of the evidence. We have to prove beyond a reasonable doubt. There's a lot, and I think something that's really important, and once again, this is all outlined in the report, and I personally wrote this report. When there was not evidence or not follow-up through the police department, we did that follow-up. And there's several times in the report that I indicate that their lack of investigation was a real hindrance. And we needed to do a lot of our
I'm sorry, but somebody
own.
died here, and you're saying
know-
that the lack of police investigation, and do I understand this right? Nobody from this department actually went out and talked to these two officers? You relied on the statements that these officers wrote up
That's
after the
all-
incident?
You're not, are you from Albuquerque?
No.
Okay, so you're probably not aware of the history. That's also on our website. These are internal reviews for 30 years under number of administrations from the 80s. These cases were all presented to a grand jury, an investigative grand jury, where a grand jury had a number of options. They could subpoena, all testimony was given under oath. They could compel people to come and testify, even if they were uncooperative. In 2012, the court said, well, we're not going to allow that in Bernalillo County, although they do it everywhere else in the state. But in Bernalillo County, we're going to suspend that practice. And our only alternative under New Mexico state law is to make an internal decision within the DA's office. So starting in January of 2013, we started issuing, we developed a protocol, and then we started doing reports. And I believe our first report came out in March of 2013, or in that ballpark. We don't have, under New Mexico law, the ability to get anyone to cooperate. We can't compel someone to come and make a statement. We can't take any statement under oath. We don't have that capability. We have no capability to subpoena records or do any of that. That's one of the flaws with this internal process that we now have to resort to review officer-involved shooting cases. We have no alternative. There is no other way of doing it in the state of New Mexico. We tried to get a bill through the legislature that would allow us to present them via preliminary hearing without filing a criminal complaint, and that way it would be all out in the open. We could subpoena people, all of their testimony would be taken under oath. That didn't make it through the legislative session this time, although we will try to make something like that happen at some point in the future. So we didn't have the capability that the court had. We do not have that capability. So we have to rely on police reports. That's what we have to rely on. We're not an investigative agency. We lose our immunity when we start investigating. We can aid the police and give them legal advice, but we can't go out and investigate. So we have limitations, and if you look at the letter that I wrote to district court, if you look at lots of comments, we say this is flawed, but this is the best we can do. Now, what we have done, in addition to writing our report, we list everything that we relied on, everything that we had access to, and we attach, if you disagree with the report, if you want to know how we reached our decision, if you want to check to see if we're being accurate, or if we're misleading in terms of laying out the evidence, we attach the reports, the statements, photographs, and everything else, so that we're being as transparent as we possibly can. This represents the attachments, and I believe it was the most attachments we had in any other officer-involved shooting case. So that's the process. This is not a process I picked. This is really not a process we designed other than out of necessity. We much prefer to have a citizen grand jury looking at it that has the power to subpoena, the power to take all statements under oath, take testimony, and the power to say we need this, we want this, what about that, and make a decision in terms of should it be criminally charged or not. And those are individuals that don't have a dog in the fight, so to speak. They represent the community at large.
So you're right, I am from out of town, so let me ask you this question. So in all of these recent shootings, and I'm going back to 2010, there's been 26 or so, not a single charge has been filed against a police officer in any single one of them. Are you telling me that's because the police in this town get to decide what's justified and what's not, and there's no other review process?
We rely, actually we started this, the grand jury investigative grand juries were suspended in the spring of 2012. So before that time, we did present to the investigative grand jury from 2010 to 2012. We have to rely on the police reports. That's what we have. That's a flaw in the system.
So the police essentially decide what they can and cannot get away with.
Right, but we have an MOU in place where there's a number of different agencies that are involved. Hopefully, if something isn't done, another agency will pick it up, kind of as a check and balance. In this case, there were issues with the investigation. As I mentioned in my report, we lay everything out there, whether it's good, bad, or ugly. We don't present a viewpoint. I criticize the police department because they didn't interview an eyewitness who made a 911 call, and that was critical to the case. I criticize them because apparently Officer Brown, well, not apparently, we found that Officer Helger into the battle tried to call on his radio for backup because they were fighting, and it was a really short phone call, and all you hear is his heavy breathing. But he says in his statement he was trying to call for backup. That wasn't in the police reports. And so we had to go back and say, was that did it happen? Did it not happen? Why don't we have a record of it? We went back and found that phone call, and I believe that you can hear that. That's one of the attachments, although all you hear is breathing, and then the radio's knocked out of his hands and is broken. But we had to go and do a lot of work ourselves because we weren't satisfied with just the information we had in the reports. Something else we did is we went to the scene so that we could get an idea of the space, of the concrete, exactly where everything happened. And we were also able to see the fence that Christine Apodaca was looking over. Both officers report that that Christopher Torres didn't cease to move until the third gunshot. Well, I didn't know if that was true or not. How are we going to know that? We went to the office of the medical investigator and said, is this true? Are they lying? And just trying to find a way to justify him being shot 3 times. We met with the medical examiner, and she said, no, that's absolutely consistent with the injuries that Mr. Torres received. So we try to do a little bit of backup work, but obviously we're limited, but we are relying on the police reports.
Karen, can I ask, I'm sorry, because I need just some clarification
Okay.
here. When you're saying that the police investigate, are we talking about state police, BCSO, the independent, or the review team?
Right, the review
Different
team.
law enforcement agencies, not just APD,
That's
but the
correct.
review team
That's
did
correct.
review this, including state police and BCSO.
Right, right. And in the statements of both of the officers and throughout, and the supplemental is attached again and is online and available, it says the officer from what agency are present during that interview.
Okay. And
Karen,
they
what I'm
found
puzzled
no
about-
probable cause for these officers.
It's really our determination to find probable cause. I mean, that's a legal standard, and they're not lawyers. So they do the investigation, do what they feel is necessary, and then they hand it over to us, and we determine whether or not there is. And you know, I think it's important to say, we work with law enforcement, but the people that are involved in these cases typically don't work with law enforcement. I don't carry a caseload because my administrative responsibilities are so much. So even though we work with law enforcement, we prosecute, you know, law enforcement officers if they violate the law. We haven't in an officer-involved shooting because we haven't found probable cause, but we prosecute law enforcement officers
Is this
on a regular basis, and we really don't have a dog in this fight. When we look at these cases, we look at them very critically. And it's just like I said, when the officer said that after Christopher Torres was shot, he continued to move. We didn't take their word for that. Even though both of them said the same thing. We went to OMI and said, is this possible? Could this happen the way that they described? So we second guess and look at everything very critically. I think another, to me, a very important part of this process is one person doesn't make this decision. We work in this, I can honestly say we spent probably 9 to 10 months working on this, constantly having meetings with other prosecutors, with other chief deputies who work on this, and really working things out. And I like to say whenever we make a decision where someone has lost their life, we at least have over 100 years of experience at the table, evaluating, arguing if the case is such, trying to look critically at whatever issue we are supposed to be deciding.
Now, Kari, what I'm puzzled about is you told Channel 13 that it was very difficult to prosecute or pursue charges for an officer if they said that they feared for their life. Yet the judge determined that there was nothing showing it was self-defense. So is that, in a sense, a cop-out for officers just to say, you know what, I feared for my life?
It could be used as a cop-out. It could be used as a cop-out. It could be used as a cop-out by anyone acting in self-defense. And so what we do is we look at the facts.
So you couldn't find anything, especially, you know, that his fingerprints were not on the handgun.
Okay, that I
their
would really
life was
like
in
to
danger.
address. I have been in this business way longer than I want to admit, over 30 years. And I have, since this came out, have talked to numerous other prosecutors that have been in this business for 30 to 40 years. I have never, ever, in my experience, had a fingerprints found on a firearm.
Can you and will you reopen your investigation?
If we have new information, right now, the court's decisions don't, it's her opinion. She was a finder of the fact. In a civil case, with civil evidence and with civil causes of action. That doesn't equal criminal. Once again, the burden of proof here is 51%. If I had that burden of proof, 51%, we probably would have pursued criminal charges. That's not what we have. We have to prove beyond a reasonable doubt. Our burden of proof is twice that. So it's a whole different thing. And that's one of the difficulties that we have is when there's a civil judgment, everyone says, well, then why didn't you file criminal charges? Well, there's tons of cases where you can file civil charges and there are no criminal charges.
It seems there's a lot of new information, though, that has come to light. Does that bear investigation and you're
Well,
looking at
most
it again?
of the things that I have read in this, and like I said, I don't know, please, I don't know the evidence. But what I've read in here, some of it's incorrect, according to the police reports that we looked at. Some of the assumptions are like fingerprints, he didn't touch the gun because his fingerprints on it. That flies in the face of everything I know in my 34, 35, I don't know, 33 years of practicing criminal law, and I've talked to other prosecutors and they say the same thing, or criminal, if you're in the criminal arena, I don't know where that came from.
So does the new information bear investigation, re-looking into? Or are you saying that you will not?
I'm saying that if anything comes to us that is credible, that would impact whether or not we can prove beyond a reasonable doubt, sure. In any of these officer-involved shootings, we will consider new evidence.
Would that have to come from the police department, or can you take it from the
No,
civil
we
case?
can take it from anyone, but it has to be credible. And it has to relate to a criminal matter. It can't be, they talk about SOP in here. That's not criminal. When someone violates SOP, that's not a criminal matter. And SOP means standard operating procedure. That's not criminal. Administrative violations, those aren't criminal. And we will not look at those.
But isn't perjury criminal? These officers, according to the judge,
Well-
told several different stories at several different times.
Well, and we looked at their statements given after the incident. One was given several hours after the incident, and the other one the next day. And we did not find inconsistencies that were major. They were pretty much in line. And it was our information that these officers had no contact. After the shooting, Christine Apodaca ran out, and she said she saw the officers. The next officer was on the scene within 2 minutes. Okay, she said they weren't moving things around, talking, trying to get their story together. She said they were just standing there, not doing anything until the next officer came. That doesn't indicate collusion or anything like that. We have all sorts of indication that there was a fight. We had sunglasses that were broken, we had a phone that was broken, we had a radio that was broken, we had neighbors that were canvassed that said that they heard yelling and screaming. We even have Christy Apodaca's statement saying that she heard the groans and moans of a battle and stuff. So there's a lot of this that corroborates what the officer said. We're not taking anything the officer said at face value. But their combined statements with all of the other evidence. They made their statement before they knew that DNA was present on the gun. How did they know the DNA analysis was going to reveal that his DNA was on the grip and on the barrel, right where they said he touched the gun?
Are these officers still credible witnesses for you in future cases?
I certainly think that the civil court's findings of fact would impact that.
Kind of scary. There's cops on the street right now.
That's, well,
I mean, come on.
You know-
Basically, they said they didn't kill the guy. You believed it, and they're back on the street.
no, I didn't believe it. I looked at their statements with all of the evidence, the forensic evidence, and Ms. Apodaca's statement.
And it was, Kari, you're just saying there was not enough to prove beyond a reasonable doubt.
Well, there was not enough to prove beyond a reasonable doubt. And let me go through this. If you guys are interested in facts, talk about inconsistencies. And I say in my statement, and I point all of these out, with Christy Apodaca, that in her April
witness.
29th deposition, she said she saw the detectives with their guns drawn before the shooting. In her 911 call, after she heard the gunshots, and I think that 911 call is available, listen to that. She calls and she's in a panic and says, oh my God, I think my neighbor's being robbed. And then I'm paraphrasing this, but we've got the transcript that's part of the record and the call. And they say, no, they're officers, ma'am. We just had a call for shots fired. And she goes, oh, okay. She says, okay, well, I just thought my neighbor was being robbed. And that's it. Then she's warned, don't go outside by the 911 dispatcher, don't go outside. She immediately goes outside. And I say this in my report, if she perceived danger or threat or something horrible.
Well, don't you think the public, if you're calling 911 and somebody tells you there's an officer next door, don't you think that's going to change your perception of what's really going on?
I'm not going, I can't judge that. I mean, I'm just saying I'm just saying that's a fact.
But you
that's
said
a
that you're
fact.
judging that in your
Right.
case.
No,
That
I
of
just said
how
you
she said
hear
in her
that.
statement, and then her 911 call,
Then-
she's completely okay after she finds
Right.
out it's an officer. Wouldn't
Maybe.
you take that into
I don't know. Yeah,
consideration?
I would. I mean, that's a tiny, like a milli 1% out of, a million different factors.
From what
okay?
you were given,
But let
do
me
you
go.
believe the officers were or felt that their life was threatened?
I have no reason not to believe that, given all of the facts of the case and given the state, the law, the state of the law. And if you look, and the law once again is in our report. Let me finish this, okay? And then during her April 29th deposition, she refers to seeing the guns in their hands. Seeing the guns in their hands, both detectives. On July 11th, in a video walkthrough, she doesn't mention anything about the guns. Then when she meets with Rich Lewis in March of 2013, she didn't mention the guns again, ever seeing the guns. And Detective Lewis says, well, is this when you saw the guns? He even prompts her, and she says, oh, no. And then she goes on and never mentions anything about the guns. An hour later, she calls him up and says, oops, I forgot to tell you about the guns. I do remember them drawing their guns and holding it to them. So, and then following the interview with Detective Lewis, she put in her memory where she wrote down, and I think that that's a part of the record, she wrote down, I then saw the man that had been punching him draw his gun, pointing it at Christopher's head. Just the opposite of what she had told Detective Lewis. Then in August 26, she reviews the events and again forgets to mention anything about the guns. Later in the deposition, she offered that the officer hitting Torres in the head, which was Detective Hilger, was the one who drew his gun and said he was going to shoot him. And she elaborates further and says, yeah, it was Hilger who shot him. We know that that's not true. There's no contradiction in that it was C.J. Brown who shot him. So we have all of these contradictions in Ms. Apodaca's statements. When we're evaluating a case for prosecution, we can't ignore those things.
Public perception of your office as an independent investigative body, has it been affected, and if so, how by this case?
I think definitely. I mean, yes. Honestly, yes. Because I don't think that the public has read this report, has read the police reports, and I still think that there's a vast lack of information regarding civil versus criminal. I think if they think someone did something wrong civilly, then they must be criminally liable. I think that that's the consensus. And so it's our job, and that's one of the reasons why we put all of this information out there. We make it available, we attach the statements, we attach the forensics reports to try to aid in that. It's my experience that most people have not read an officer-involved shooting report.
How might this case have been different had it been an average citizen, not an officer, that was accused of?
We've
this
asked ourselves that many, many times. That's part of our process in analyzing and evaluating and critiquing. And what if this were someone with a criminal record that jumped into somebody's backyard and they did this? Once again, we couldn't trust just what he said. We couldn't trust we'd have to view it in the totality of all of the information, the forensics, and all of that nature. Now the difference is the law does treat an average citizen differently than they would treat a law enforcement officer. A law enforcement officer has much broader discretion. A law enforcement officer can be the aggressor initially and still use self-defense as a defense, where an average citizen cannot. So the law is different. So that would certainly be part of the equation.
Will you take any evidence from the civil case and look into pursuing charges against these officers again?
Well, if we have anything given to us that relates to the criminal matter. Now, if they give us something on they violated SOP or they didn't have their video cams on, that's not part of the criminal. But in any case that we have that we've closed or that we're not pursuing, if we get any evidence that would indicate, that would throw it over, then definitely we will do that. And we've always said that in our officer-involved shooting cases. Certainly the more serious the case, the more important it is that we evaluate that evidence. We worked with the police department. We worked with and once again, it's contained in the report. And we got information from the the attorneys representing the city of Albuquerque, and we also worked and got information from Miss McGinn, or the Torres' lawyer, and we met with them at least on one occasion to exchange information and get their viewpoint on it. And the families, we attached a letter from them to our report, and we always seek the families or the victims' families' input in these.
What do you say to the families, to the Torreses right now about this, about what the judge said yesterday and what you're saying today, that you cannot seek charges at this time against these officers?
I have to tell you, honestly, I thought there was civil liability. I'm not surprised by the fact that the judge found civil liability. I'm going through this and I'm thinking there's civil liability, and I'm not schooled in civil law, and that's not my area of expertise. But I thought that there was civil liability, so I'm not surprised by that. What can I say to the Torres family? Nothing can be done to bring Christopher back. I mean, all indications were they were an extremely loving, caring family, and that they lost their son. You know, what do you say to someone that's lost their son in a very tragic circumstance? You know, my heart goes out to them. Does that mean that we can file criminal charges against the police officers? We need evidence to prove beyond a reasonable doubt that they committed a crime and that they had criminal intent at the time that they committed the act. And for your benefit, on our website, we also write national statistics on officer-involved shootings, because when we were not allowed to take cases to the investigative grand jury, we started doing research and said, well, are we doing something wrong? Are we off? You know, and start really critiquing ourselves in the process. And we found, and then that once again, that's all on the website, but that the Ellison report, and I believe that was in 1997 out of Colorado, Denver, when they had a lot of issues, that 1 out of 500 officer-involved shooting cases result in an indictment, and 0 are convicted because of the law. And we went and we list a number of statistics, and all across the country. I mean, in hundreds of cases, officers typically are not indicted because the law allows them such discretion.
Let me ask you one other question. You must have seen this video of James Boyd being shot.
I've seen what's been in the media, yes.
Based on that, is there enough evidence as the district attorney to seek charges?
As a prosecutor, you would not want someone to look at one video and ignore all of the other evidence and make a decision. The people of Bernalillo County, and this is heartfelt, deserve us to spend hundreds of hours on these to make sure that we have all of the information and all the evidence that we can get before we make a decision. And we work very hard not to shoot from the hip. People that we represent deserve more than that. So yes, I saw that video. I'm a human being, and I think it impacted me in the way that it impacted a lot of others. But as district attorney, I have a responsibility to look at all of the evidence, not look at it, study it, discuss it, critique it, evaluate it, see if we need anything else, and then make a decision. And then share that decision in a report with all of the attachments. So that if anybody wants to critique us, argue with us, say we've made the wrong decision, we're giving it all to them, because that's part of what they deserve as well.
Is your office actively looking at that case?
Not yet. It typically takes about 6 months for us to get that information. And so it'll be petering in, and usually after we get it all, it will be evaluated and looked at and discussed. And in a protocol, it's our goal that within 6 months after we get our last report, our last law enforcement report, then we issue our report. I can't say that we can always make that, but we will try to do that. So we'll spend 6 months evaluating it, looking at it, sleeping with it. And I don't say that facetiously. I mean, we take these things to bed with us, we live it, a number of people, so that we can make a good decision. But we're always bound by the law. We can't sometimes do what we want to do, or do what, our gut tells us we want to do. We have to follow the law, and we all take an oath of office to follow the law.
Kari, as a taxpayer, you were raised here with the dollar figure mounting. Is that disturbing to you, these multi-million-dollar lawsuits?
Yes, as a taxpayer.
What's been the nature of your office's interaction with the Department of Justice?
We met with the Department of Justice when they came into town, talked to them about our process, what we do, and I think we met with them initially when they came to town. We met with them another time and talked about the officer-involved shootings and how we handle them in the process, and the switch over from presenting them to grand juries. And then at the conclusion of their issuing their report, we met with them. I believe the day after they published their report.
So just to clarify, can I go back to the fingerprints on the gun? You did or did not find any?
No, they actually tested fingerprints on the gun and didn't find any fingerprints on the gun. And that's included in my criminalistic section, that they did test it for fingerprints, but they didn't find any. It's my understanding from reading this that she said because they didn't find any, then Christopher Torres didn't touch the gun. My experience as a criminal lawyer is that I have never had fingerprints on a gun. I mean, it is you're going to get my fingerprints off of glass, maybe plastic, hard metal, steel. It's much more difficult to get fingerprints.
Is that what you think she based all of this on?
No, I don't know. She just puts that in one paragraph. She notes that, and it's just my experience. You never get fingerprints off of a gun. You test for it, and you always request that it's done. In my experience, I've never seen it in my 34 years. I don't recall seeing it. Since this came up, I've asked other prosecutors who are career prosecutors, and they all have said that they have never seen it either.
For the officers, no fingerprints of the officers or Christopher Torres?
They said they received, actually, let me just refer here if you want me to be accurate. Criminalistics. Hilger's firearm was processed for prints using black Latin print powder. The results were negative.
For everybody?
It just said the results were negative. So it didn't, I would think that would be for everyone.
How many people total then investigated this case criminally?
Oh, I think it would be impossible to say, because they had a lot of people show up at the scene and canvass the neighborhood. I mean, so I couldn't even give you a number on that. I would think clearly that had some role in this, at least dozens.
And you said in your office they had more than 100 years experience?
Well, we had all of the chiefs, myself, would include other people at times. Oh yeah.
And what's that review committee called, or the review, it's not a review board, but with these.
Oh, the POC, the Police Oversight Commission?
Not the POC, but it's a different group with state police. Whenever there's an officer involved shooting, they go out and investigate. There's a certain outfit on it.
Okay, the shooting team or,
The shoot team, yeah.
okay.
So just so I'm clear on this, since it's an IA, and you are now taking over, you're limited on what evidence you can have, pursue, or interviews you can pursue.
What do you mean,
Is-
since it's an IA, I'm
You said
sorry?
since it was an internal affairs investigation and then they turn it over to you, you're limited on what evidence you have to look at to determine if there's a charge. Is that correct?
I don't know, I didn't refer to internal affairs, so I'm sorry, I don't.
Okay, then what type of case is this that's different than the average person because it's a police officer?
Okay, the law gives a police officer wider discretion in using deadly force than it does in an average citizen, or using deadly force to defend themselves or a third person.
Okay, because you mentioned that you're only allowed to look at evidence that the police department gives you versus
Right.
going out and actually doing your own interviews on
Right.
these type of cases.
Right. Right. I mean, we can go out and talk to people, but typically we don't conduct or control the investigation because we would lose our immunity if we did so.
So you rely on the shoot team for your.
So we rely on them, and we'll do follow-ups. Like in this case, we met with OMI. We just did a follow-up to clarify information. We also asked for information on the call, because Helger mentions I tried to call for backup. I don't know what happened. My radio went flying. And so I said, let's check that out, because to me, I thought that was really important. And we're able to check. I think it went to the Northeast Command versus the Valley Command, which they were looking at. And it showed that that something did come in from his radio. You hear the really heavy breathing, and then nothing. The radio's is thrown out of his kicked or whatever out of his hands.
And is it a specific case? What could we call this? Is it just because it's a police officer and that's why you're only limited to what they give you and you can't go pursue your own?
No, because this process doesn't allow us to compel witnesses to talk to us. Okay? If it were a criminal case, we can subpoena people to come talk to us. This isn't a case yet. It's kind of something that we're reviewing, and we don't have the capability of subpoenaing. We can't take statements under oath, and we can't compel people to cooperate
you're
if they
just
don't
reviewing-
want to
Until a grand
cooperate.
jury says go ahead with it?
A grand jury has that power to do that.
So you
yeah.
have to take it before the grand jury
Yeah,
and get
and the grand jury could do that. And we always had that power when we were presenting cases to a grand jury.
And when you speak of immunity, could you clarify that?
Well, immunity
from-
means that we're working, what would be an easy way of saying
And
that? Because we exercise certain official responsibilities and duties, the law protects us. So say that if we charge someone with residential burglary and a jury acquits him, the law gives us immunity so that person can't come back and sue us for our home and our vehicle and everything else. Judges have immunity.
Okay.
Most government officials do have
Civil
immunity.
liability
Right.
immunity.
And that's important to us because we don't want to lose our homes.
Right, yeah.
Did you try to talk to Christy Apodaca at all? I mean, even if you couldn't compel,
Right. Actually, what we did is we relied on her statement that she gave to the McGinn Law Firm, her initial statement, her walkthrough. She did talk to Rich Lewis, and that was at our request. We said, Rich, would you go out and talk to her? And that was a telephone interview. And then we did get a copy of her deposition in August.
What's missing that the civil case has that you're?
You know what? I don't know, because I don't know what was presented in the civil case.
So will you go through the civil case and see if there's anything
Well,
there that bears further?
We have no ability to go through the civil case. We'd have to get a transcript, and that would cost tens of thousands of dollars. And if we
Is that
start,
not public record?
well, but we still have to pay for it because court reporters prepare it, and they have a right to be paid. So
So
if somebody
the
can-
gist of this is, you have a much greater burden of proof.
we have it
Okay,
twice.
Is that the bottom line?
You could argue we have twice the burden of proof that they do in a civil case.
Preponderance versus beyond a reasonable doubt.
It's
Yeah,
huge.
It's a big
It's
difference.
huge.
So that's the bottom line.
That's a
That's-
bottom line. Well, it's not that, I mean, there's a lot of bottom lines. I mean, it's complex. I don't want to give anyone the idea that
So
You're
it's
not allowed to go
simplistic.
through the grand jury anymore.
No, we're not allowed to do that anymore.
And that was New Mexico law that changed that?
No, it was the Second Judicial Court said that they felt that that it would be better if we just made internal decisions.
So grand juries that looked at officer-involved shootings were done away with, and then this independent review team or.
And we argued with the court, and we said, you guys are really cutting us off at the knees here because we don't have the capability that the grand jury has. You know, and there's that potential conflict. We don't believe that it's a conflict, but there's that potential conflict that we work with officers, and so we'll cut them a break. A grand jury doesn't have that issue.
I think that's the
Yeah,
problem
and
of
trust
perception
me.
out there. That's
Yeah,
what
and
it
trust
feels
me.
like to-
And we do prosecute officers. We prosecute a lot of officers when they break the law. We just haven't been prosecuted one involved in an officer-involved
Do you know
shooting.
how many cases civilly that have been won that you have not been able to prosecute?
I don't know that. No, I don't know that. But once again, you're talking about, you know, they could, you know, there's lots of civil actions. I mean, most civil actions are not a violation of the law, criminal law. And so it's totally within the realm that you would have civil judgments and not criminal.
So you're not saying that you're not gonna further investigate because of a few
Well,
$1,000
I don't
that you-
investigate, but if
No, no,
some,
but I mean-
yeah, no, if we had credible evidence,
But if there were evidence in this civil
Would you
case,
risk spending the money to get the transcript?
we would be willing to talk to people, but we don't have the funding to do that.
So
We don't
if-
have the funding to run this office the way that we're running it,
Right.
but we're working extra hours to do that. So,
so if lawyers involved in the civil case were to come to you with a
Yeah.
transcript of the case and say, here it is,
right, but it would have to relate to something criminal. It couldn't be a violation, a standard operating procedure. That's
Right.
not a crime.
But if somebody brought it to you, would you guys look at it? And
Yeah,
think
we look
about
at
opening
it.
the
There's
case?
nothing in here from what the court said that I see that would impact, based upon what we have here, that would impact the case. My background in criminal law tells me, I mean, I have a different background. So I have different information and I have different experience. Like the fingerprints on the gun seem to weigh heavily. To me, I know you never find, I mean, rarely would you find fingerprints on a gun. So, I mean, there's those two different, and that's the difference between the civil arena and the criminal arena.
Is this just Torres's case, or is this several other cases?
No, this is all of the attachments in the Torres case.
Torres case.
So this is, we write the report and then this gives you all the information. And we refer to it in here, where you can find it, Exhibit A, Exhibit 2, or whatever. And we also include photographs.
is that online as well?
Yes,
Or just
all of this
that's
is
all
online. All of this is online.
And so is your review?
So is our review, so is all of the case laws in all of the reports. But also what's important, people don't, you know, it's important that we're not the only jurisdiction that is saying, you know, the law makes it very difficult to prosecute a police officer who says he's defending himself in the line of duty.
Does the
And
law
we
in,
go
like,
through
New
all.
Mexico, in New Mexico, well, from what I understand, it's an officer, and that's just exactly it. An officer has the right to defend himself, and that's what these cases are.
Or another. And there's a specific law in New Mexico, Mantelli, and we refer to several Supreme Court cases, Graham versus Connor, that indicates the same. And they say, you know, we're not going to go back and second guess what an officer did, because they don't have the luxury. They have a millisecond to make a decision. And we can't go back and spend 50 hours analyzing what they should have done when they don't have the 50 hours to analyze what would be the correct move. And so that's part of the law as well.
What kind of mechanism needs to be in place from your view to prevent this misperception and these seemingly, I mean, it's been a rash of shootings and officer misconduct. How would
you
we
know,
fix this?
You're asking, if I had the
Yeah.
answer to that,
Yeah.
I'd tell you what. I think public education is important. I would love for people to go on and read one of our reports. I was even talking, an attorney was criticizing them, and I said, well, have you read one? And, well, no. I said, well, just read one. I mean, and then you don't have to agree with us, because we give you everything you need not to agree with us. But just look at it. Are you familiar with the law? Well, no, I'm not familiar with the law. Well, become educated. And then let's really talk about it. And we're open for discussion. We critique ourselves all the time. We're open to doing better, to learning, to listening to complaints. But we have to deal with facts and the law.
Is it safe to say that APD is allowed to limit the evidence they want to give you that could probably hinder if their officer is ever going to be charged criminally?
We have seen, in some areas, poor investigation. We have not seen a cover-up.
Would you say the investigation on officer-involved shootings is a lot more minimal compared to actual?
No, it's a lot more than it is in typical cases. We have a lot more in officer-involved shootings. They, I think, put a lot more resources into those cases than they do their average cases.
What about separating forensics and criminalistic investigation from the police department
Now-
and the DA, making that an independent agency?
Well,
kind of
you're
deal?
talking
Is that-
about huge changes, but the people that work in criminalistics and forensics will tell you they're scientists. They're not advocates.
But they work for the PD,
Same with
right?
OMI. They're connected with the police department, but they find as often as not, in a lot of cases, they hurt us. Because science is science, to some degree, and it's not black and white. So, I mean, but one of the questions that I ask is, you know, that to me is common sense. Is everyone going to put their career on the line? Everyone, for an officer that they don't even know. And I'm talking about a lifetime career, education, degree, their integrity, their ability to face their children when they go home at night. Are all of these people going to put all of that on the line to protect an officer that did something wrong?
So you
Kari,
said-
on a scale of 1 to 10, how would you rate this investigation that was done on this case?
God, that's really hard.
Overall, how would you?
Because they didn't interview the eyewitness, I mean, I'd have to give it a 3. I mean, I would. When you don't interview someone that calls 911 that was an eyewitness, you've got their information. I just think that in and of itself knocks it down. They did canvass the neighborhood, and a lot of other areas were well done. But when you miss an eyewitness,
And you mentioned
I
you
think
don't
That's
that's
what you have to
huge.
rely, your prosecution is on.
But what we did is we try to compensate for that so that it doesn't interfere. We can't guarantee that, but we compensate it for that by having her interviewed and by getting copies of her statements and depositions. And we did that with the cooperation of the McGinn Law Firm.
And so which witness was it? I know you kept talking about the neighbor who was behind them, but what other neighbor wasn't?
It was
Or-
Christy Apodaca. She was the one who saw it from her backyard, or who saw parts of it. Another thing that's
But
really
they interviewed
important.
her. Is there another?
They
witness?
didn't interview her until 2 years after the fact. She called 911, gave her name and address, and they never interviewed her until we asked that they interview her 2 years after the fact. But something else that's important is this lasted about 4 to 5 minutes from beginning to end. It happened really fast, okay? She said she saw 30 to 60 seconds of it.
But this is her perception of it
Yeah.
2 years removed.
Right.
So,
But she says she saw 30 to 60 seconds, but everybody's acting like she saw the whole thing. In her own words, she says, I only saw 30 to 60 seconds.
So did you said that you went through another law firm to get her statement.
We went through the McGinn Law Firm to get
Did you
copies of her
use that
statement.
as far as?
Absolutely,
an
and it's in my
investigation?
report. It's in my report, yeah.
So then why did you say earlier that you're not allowed to go get interviews on cases like
Well,
this?
they gave them to us. No, we were in this case. I mean, we can't go and get court records of civil cases. We couldn't do our job if we did that, and we've got a responsibility. But in this case, because we needed her statements and we needed all of them, we went to the McGinn Law Firm and they gave them to us. We needed to do that in order to write this report. We could not have done a report without that. It would have been incomplete with them.